He should have said, upon hearing the evidence.
Upon reading.
Upon reading the evidence. And not only that, was I the only one in court? Was it barristers? Obviously not by this judge, because he only refers to us. He has to refer to all parties. That he didn't. So he's put the date on down the bottom and at the top, but that could have been printed at any time. The seal makes the document. So there are an awful lot of other things in this document, but just for general reference, it's worthless. So now it's back in court, so we can get a proper judgment with the truth. The guy will go into more information.
Yeah, and of course Tom's next case is about the review and revise. So that's what that's about.
Yeah.
So it's not an appeal, but it's a review and revise. You've made headway for that today, haven't you?
Off
that. So we want clarification about exactly what's happened in their process and proceedings. And talking about process and proceedings, that's where a lot of this stuff falls foul, because there is no law without due process. No due process equals no law. So now due process of law is a constitutional guarantee, and it's guaranteed to us through Magna Carta section 39, and even in the civil procedure rules to a certain extent there is a guarantee that the rules will be adhered to under the overriding objective, which none of the CPR rules can do anything without the overriding objective being adhered to. So what's happened in these cases is they haven't been to court. You can find out if something's been to court by going and examining your court documents. And the reason I'm saying this is because law without process doesn't exist. It has to be due process, and due process has to be seen to be done.
Yeah.
Not, as in a famous case, not only must justice be done, it must also be seen to be done. And of course we need to see the documents that they're claiming they've got, or they're claiming that has initiated the actions against Tom. And of course none of these have been forthcoming. So there's no evidence that there's ever been a court case against Tom. And I'll use the reference of what I was saying before. And we've shown you claim forms, and we've shown you seals. And in this particular case here, you'll see this gentleman, this is actually something they've trying to take his property off him for. And there is no seal in his court file, so there's been no process for this to go through the courts. So there's never been a court case. And when you turn over the page, you see that there's no signature. Now the same as in Tom's case. But this is just a printed one. I don't think there was any signature at all in your case.
No.
So there's no evidence that any of this stuff has gone through the court. And without that, without due process, they have no law. They haven't gone through that. It's fundamentally flawed. So in all these areas and issues to do with accountancy, etc., show us the ledger with the correct accountancy procedure and including all the payments for the court's due process. Again, a judgment means nothing without jurisdiction. So the judge at that point had no jurisdiction to make anything for any appeal, because there was nothing to appeal. And that's quite simply why Tom was refused an appeal. An appeal had no merit because there was nothing to happen. There was nothing happened, and it's quite clear in the judgment itself. And right. So in Tom's case, not only did the court case never even start against him, because there was never a claim that went through the court, never any fee paid, never any court seal placed on a document to establish that it's gone through the court process. It gets worse, because every stage, when you analyse the process and procedure of it, it falls apart. And they've got as far as going to the notice of eviction. And again, people tend to think these are court documents. They're not. They're just forms printed out.
Yep.
And this notice of eviction is as far as we've seen. Now, that's supposed to be attached to the warrant.
That's right.
Now, the warrant doesn't exist. Well, it's like, they talk about it, it's like the golden fleece or something, you know what I mean?
It's supposed to have all an affidavit attached to it. It's supposed to have all the information of of monies that's owed, is have to have every bit of the process attached to that warrant.
And none of it applies. And as far as I'm concerned, from the very beginning, there's no need to go any further, because when you take a claim form, you get a claim form offline or whatever, you take it into court, and you go into the court with it, and you pay your fee, and it gets sealed. That means it's been processed by the court, as in the copy we showed you. So when this gentleman went down and put his court documents in, they gave him the seal, he paid a fee, which he can produce a receipt for, and he signed the document. As simple as that. Now, in Tom's case, none of that has happened. So we've got no evidence there's ever been a court case. From that point, we can argue about the later procedures that went on, and whether or not they actually happened either, because none of them are signed or sealed or anything, which they should be. They must be, to be compliant with their own rules.
The judge knows this as well.
The judge knows this, and so really and truthfully, we're in a situation where
he's been sitting in fraud, basically.
He's been sitting in fraud, and if they're going to come with if they're going to come to your house at any time, show us the documents. That's all we ask. People don't hand the keys of their homes over
Don't do it
without making sure that the correct procedure to the prescribed form has been adhered to. And unfortunately, people have been doing that, and everybody's been getting robbed. Everybody shouldn't be examining the process procedures. And if you were wealthy enough to afford a lawyer and pay him £1 million to attack Tom's case, the first thing they do is attack the process and procedure. They wouldn't go into the merits of the case and all that. It would take hours, and they're not interested. They know where the faults lie, and the faults lie in the process and procedure. Yep. And a lawyer will probably take a lot of heat off the Law Society, because as an officer of the court, he's not supposed to undermine the court process. But unfortunately, the court process is running a criminal enterprise, for want of a better term, and a lot of these people know it. They're either criminals or cowards. And to prove the point, just show us the documents. Show us a claim form with a seal on it and the fees paid, right? Show us the warrant. What is it? Why this mythical beast called a warrant?
So basically, we've covered the the two major points that people wanted to know, which was permission to appeal is refused. You can't refuse. You can't do anything unless it happened. You can't stop something unless it started. So there was no procedure.
Yeah.
And the execution of the warrant doesn't exist. What they're actually talking about is the execution of the notice of eviction.
I'll tell you what to do.
Nothing else.
I'll tell you what people can do, Tom. Appeal something that hasn't happened. Go down the court and fill out all the forms to appeal something that hasn't happened in your life, and see if you get granted the appeal.
Yeah, exactly.
See if they grant it.
So nothing happened. There was no warrant, and the only thing he could actually do is lift the stay of execution. And it isn't of the warrant, it's of the notice of eviction. And that will be broken down to in part two, in the documents itself.
And what we've been flicking in and out for is because this stuff's going on an industrial scale throughout the United Kingdom. Tom's case is highlighting this, and that's why, I know there hasn't even been a case against Tom. There's no documents to support that there any merits that there's been a case against him, and none of them any documents are not to the prescribed form and haven't been through a court. But that's another issue, because people are talking about appeals that have been for things that haven't happened anyway. So we flick in and out, but it's all very obvious when you boil down to the nitty gritty, and you just want the evidence. We want the evidence.
The way I explain it sometimes, it may be correct or wrong, it'd be like standing in front of a big red double-decker bus and complaining to the conductor that he's missed the bus that started, and yet quite obviously it hasn't left the base. That's the same as ours. You cannot appeal something that hasn't taken place. So let's hope that's cleared up that one. It may be a bit confusing to understand the stay of execution, but that will be addressed in the actual part 2 in the documents. But we're absolutely 99.9, because we are dealing with criminals here, that Sue and myself's home is safe. And if this stops a lot of the chit-chat and infighting that it's caused, and it's been instigated by certain individuals, but they've got their reasons. I'll leave it to them. But I hope this clarifies things for you all.
Yep. Right, as far as the claim form goes, which you presented to the court.
That's right. All filled out very nicely, very eloquently, and very precise.
The judge didn't make any reference to it.
No, nothing.
None at all. So what would you assume the reason for that was?
He couldn't address the facts. He only could address the hearsay of the barrister.
Of the barrister for the bank.
Yeah.
Right. And of course the actual figures, none of them added up, as we know, as the judge said in his judgment. So he couldn't actually be dealing with any factual figures even.
Nope.
And we didn't have a competent witness called at any stage in the game.
No, except myself.
Except yourself. In which he claims that you're the only thing he heard in the court.
That's probably correct then.
Yeah, because anything he saw was in fact false. So, when we go back to the file, what would we expect to see? Someone's originally made a claim against you, and then there's been various proceedings where you've made applications and they've made applications. So inside the file we'd expect to see proof of fees paid,
Yep.
requests for applications for whatever it is, a warrant, or
Judgments.
judgments,
Just a simple thing like a judgment would be nice.
and we'd expect to see those documents complete, chronologically correct.
That's
so
right.
in order, and if everything was running right and it was running through a court, we would.
Yeah.
But when we go to the court, we find
They're not there.
they're not there.
No.
So what evidence is there that the law must be seen to be done? So what can we see to prove there's ever been a court case against you?
There was absolutely nothing.
Absolutely nothing.
Except I physically end up sitting on a bench in court